Friends, this week, this Saturday, I'll talk to you on a very important topic, on a matter that concerns every one of us at some point or the other. There are times when people fall terminally ill, bearing the pain and ignominy of living like a vegetable, dependent on friends and relatives who may not have the interest or time to care, but yet cannot do anything about it. Should they be allowed to decide if they want to live at all? This is a serious question, for who else can decide whether to live or die, who bear excruciating pain and have to live with nothing to hope for except such people themselves? Should they be medically assisted in dying? Who will pull the trigger then? 25 years ago, the Northern Territory of Canberra had world first laws on medically assisted dying. In the following year, a 66-year-old carpenter had a ham sandwich with his wife and a visiting doctor, watched soccer game, and then died precisely when he had planned to at 2 p.m. Bob Dent, who was suffering from prostate cancer, was the first person in the world to take his own life under a legal voluntary euthanasia scheme. And the doctor in question, Philip Nitschke, facilitated it with his own custom-built machine. The doctor was later deregistered. When he assisted the death of Nigel Bravely, a depressed but otherwise healthy man who took his own life. The Indian Supreme Court in 2018 legalized passive euthanasia and approved living will to provide terminally ill patients or those in persistent and incurable vegetative state a dignified exit by refusing medical treatment or life support. The decision flows out of interpreting a fundamental right to live, as including the right to die. Though pragmatic in a certain context, it can have far-reaching consequences when not monitored. The whole idea can be misused. Obviously, more regulation will follow in the hope that this will not be misused like Dr. Philip did. Is our country really ripe and mature enough to absorb the nuances of life and death with dignity, so to say? The right to life is a moral principle based on the belief that a human being has the right to live and in particular should not be killed by another human being. The concept of a right to life arises in debates on issues of capital punishment, war, abortion, euthanasia, and public health care. Right to life assumes significance only when it is read in conjunction with the right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies, and right to privacy. A state guarantees its citizens that this indeed is the case. In a country as large as ours, as disparate as ours, with a population as diverse as ours, have the state and the courts been as successful in ensuring that the fundamental rights are not infringed upon? Forget infringement. Have they even been seen to be made applicable to everyone in the same measure? The crux of the problem is, have we succeeded in providing a quality life to everyone? Have we really implemented right to live with dignity to all our citizens before we even discuss the right to die, with or without dignity? Living will is where individuals express their wish at a prior point in time when capable of making informed decisions regarding their medical treatment in the future when they may not be able to make an informed decision. In Australia, living wills must be signed in the presence of two witnesses with rules on who can be a witness, not if she is a substitute decision maker in the living will, and not if she stands to profit directly or indirectly from the person's death, and not if she is a health practitioner for the person writing the living will. If the same is applied here, it has massive implications if we understand the fine print. We still find, almost as a rule, people who cannot care for themselves, people cast away in so-called old age homes, care homes, whose only prayer to the Almighty is deliverance from their hell. People with only a torso begging on the streets, children and women cast away like no one's business, and brave legal workers coming to the cities for work, packed like sardines in clusters that are living holes, trying to make something of their leftover lives. If they all, apparently with a cause to live a dignified life, when they had set foot on this earth, now feel cheated by the state, were to invoke right to die, or even if someone else were to do this on their behalf as a public interest litigation case or a PIL, or if they were to sign their living will, would the courts entertain? Would the government be held responsible for having guaranteed a right to life, guaranteed to live, and now is actually found wanting? Euthanasia advocacy began in earnest after the World War I In 1920, when two highly respected German academics, Karl Banting, a law professor, and Alfred Hoche, a physician, wrote Permission to Destroy Life Unworthy of Life, which advocated euthanasia as a compassionate healing treatment. The authors argued that mercy killing should be permitted for three categories of patients upon request of competent patients or the families of the incompetent, the terminally ill or morally wounded, people who were unconscious, and disabled people, particularly those with cognitive impairments. Reasons, noble as may seem, are fraught with dangers if applied to an entire humanity as a law. Euthanasia, as is currently understood, occurs when one person ends the life of another person for the purpose of ending the killed person's pain or suffering. Some people also use the term passive euthanasia to describe a death that occurs after undesired life-sustaining medical treatment is withheld or withdrawn. This is a misnomer. Euthanasia, at least as the term is presently used, involves intentional killing. That being so, passive euthanasia is not euthanasia, since death, when it comes, not everyone who has life-sustaining treatment dies as a result of withholding that treatment and is naturally caused by the underlying illness or injury. Assisted suicide is closely related to euthanasia. An assisted suicide occurs when one person gives another person the instructions, means, or capability to bring about their own demise. If a smart lawyer's argument retrofits this definition to the plight of hapless individuals or to the benefit of a crook for a price, one can possibly get away with planned so-called perfect murder. Active euthanasia is a death caused by lethal injection of drugs, including physician-assisted suicide. What then separates passive from active euthanasia? Would the oath of a doctor not be simply Hippocratic and the state supporting it to boot? Despite having one of the fastest growing economies in the world until the pandemic struck, and now slowly clawing back with the potential to reach 8% or thereabouts soon, and a sizable consumer economy, the World Bank report shows that India has 179.6 million poor people out of a total of 872.3 million, almost 20% of the world's poor. Our constitution guarantees free health care for all the citizens below the poverty line. The government has been doing some tremendous job on this. All government hospitals are required to provide free of cost health care facilities to the patients. Be that as it may, on paper, the truth on the ground is anything but palatable, both in terms of quality of health care and its availability. Children die by the dozens in government hospitals, sometimes for lack of oxygen cylinders, and sometimes for lack of appropriate medicines. Shouldn't an affordable healthcare system and the right to live with dignity be made available to everyone, and the default on this be made punishable by passing strictures against the state or the central government, and maybe even bring them down before right to die is made legal, even if it is passive? We seem to find answers to all our ills within the unequal ecosystems that we have created for ourselves, in the hope that the systems will correct themselves. What is the difference between killing for vengeance, killing for power and authority, killing for justice, or even passive assisted killing? The only difference lies in the expected outcome and the cause of these actions, which is not important when compared to their similarity. It is indeed necessary to know who would pull the final trigger. Is it the patient himself or the doctor who assists? Is a living will enough to exonerate all perceived guilt? Euthanasia is currently illegal and punishable as murder throughout the United States. Assisted suicide is a felony akin to manslaughter in most cases, proscribed either by statute or court interpretation of the common law. Internationally too, both euthanasia and assisted suicide are almost universally outlawed. Poetic justice extols, जिंदगी जख्मों से भरी है, जिंदगी जख्मों से भरी है, वक्त को मरहम बनाना सीख लो, वक्त को मरहम बनाना सीख लो, हारना तो मौत के सामने है, फिलहाल जिंदगी से जीना सीख लो. The entire subject of euthanasia is so inextricably linked with ethics, values, morals, respect, dignity, rights, religion, law, and medicine that it is at best good enough to be implemented only on a case-to-case basis and not legalized as a law. Friends, that was some food for thought. You could think back at the points I raised or pass it over as uninteresting. The choice is yours. If you did the first, you could be a rational being. If you did the second, believe me, you need counseling. Until we meet next Saturday, 1 p.m. Happy weekend, stay safe, stay healthy, and thank you. Namaskar and Dhanyavad.